The rules of advocate's duty toward the client. First, bound to accept the brief. The advocate should accept the brief from his client. Every detail or every happening or every event that has been occurred in his life or in those circumstances, it should be noted in the chronological order, and he should, so that he can link all the events in a serial manner and present before the court. Second one, not withdraw from the service. When the advocate accepts the wakalatnama, or when he takes his vakil patra, then he should not back out. He should complete that task, whether it is in his favor or not in favor, but he should complete that work. He should not withdraw from the service. Then not appear in matters where himself is a witness. If the advocate himself is a witness for such case, he should not take up that matter and he should not present that case before the court. Then full and frank disclosure to the client. Whatever the consequences, whatever the circumstances will go on, whatever the circumstances or whatever the happenings or whatever the consequences will take place because of any act or because of any action, then it should be frankly and freely spelled out to the client. So the client should get convinced what are the consequences that is going to happen in future. Then uphold the interest of the client. As an advocate, it is his duty that he should protect all the interest of his client, whether it is in the terms may be spoiled or may be good, may be bad, or during the course of the work or during the course of the matter. So he should uphold the interest of the client. Then not to suppress the material or evidence. This is again wrongdoing. Not to suppress any material or any fact or any evidence that for the prosecution of criminal trial should conduct the proceedings in manner that it does not lead to conviction of the innocent. Innocent should not be penalized. An advocate shall by no means suppress any material or evidence which shall prove the innocence of the accused. Then not disclose the communication between the client and himself. The communication should be secret and private, and because it is directly or indirectly affects the mutual interest of the advocates and the party also. So communication between the client and the advocate, it should not be disclosed before any other third party. Then an advocate should not be a party to stir up or instigate the litigation. Advocate should not provoke the client that you file the case or you file the petition before the court and etc. etc. He should not provoke the client. An advocate should not act on the instructions of any person other than the client or the client authorized agent. In short, the advocate should mind his own business. He should not interfere in his or her other's business. Not receive interest in auctionable claim. The advocate should not trade or agree to receive any share or interest in any auctionable claim. Nothing in this rule shall apply to the stock, shares, and debentures of government securities or any instrument which are for the time being by law or custom negotiable to any mercantile document or titles of the goods. Not to bid or purchase property arising the legal proceedings. An advocate should not by any means bid for the purchase either in his name or his other name for his own benefit, for the benefit of any other person, any property sold in any legal proceedings in which he was or she was in way professionally engaged. However, it does not prevent an advocate from bidding for the purchasing for his client any property on behalf of his client, provided the advocate is expressly authorized in writing in his behalf. Not to bid or transfer the property arising in the legal proceedings. An advocate should not by any means bid in court, auction, or require by way of sale or exchange any other mode of transfer Then do not adjust fees against the personal liability. An advocate should not adjust the fee payable to him or by his client against own professional liabilities to the client, which does not arise in the course of his employment as an advocate. In short, the gift and the kinds should be avoided by the advocates. An advocate should not use or take advantage of the confidence respond in him by his client. The trust of the client must be ensured by the advocate. Then proper accounts, he should maintain the proper accounts. Then divert money from the accounts. He should not divert the money from that account, whatever the purpose for that he has received the fees. That fee must be utilized for that purpose only. He should not divert the amount. Then intimate the client on amount. He should intimate to the client for the amount time to time. Then adjust the fee after termination of the proceeding. He can adjust the fee after the termination of the proceedings. And he should provide the copy of the accounts. An advocate shall not enter in arrangements whereby the funds in his hands are converted into loans. He should not lend the money to the client. He should not appear for the opposite parties. So these are the duties of advocates towards the client.